the principle is the same.
Yes.
My Lord, unlike the normal appeals whereby the jurisdiction of the court is invoked first by a notice of appeal and then a memo, my Lord, currently, under the rules of this court 2017, an election court can only, a court of appeal sitting an election court can only be triggered by a notice of appeal that is properly filed and that is compliant with the Rule 6 entirely.
Yes.
My Lord, I'm aware when I was preparing this this morning that you sat in another bench in 2017, I think 2018, in the case of Babo Wino, whereby this issue was raised. And my Lord, the court said that it blamed the notice on inelegant drafting. Inelegant drafting. However, my Lord, that issue has been superseded by this decision of Anwar Loitiptip, because that was an earlier decision, and that precise issue about whether a compliant notice of appeal under the rules of the court 2017 had not been addressed by the Supreme Court.
Yes.
So, my Lord, our submission is that if in your notice of appeal you do not particularize what you want as set out under Rule 6.3, and under Rule 6.3d you concisely state the relief that you seek, then if you are before this court, my Lord, it is just an academic exercise. You do not have jurisdiction to proceed because that door has not been opened. And my Lord, our respectful submission is that the controlling authority on this point is the decision by the Supreme Court, which is binding in terms of Article 163(7) of the Constitution.
Yes, Counsel. Anything else?
Lord, will be our submissions.
My Lord, may I add one line to the submissions? Yes. Yes, my Lord, the interpretation of Rule 6 is now settled in two decisions. A further decision of the Supreme Court, the decision of Musa Sirma versus IBC and others. I think that is common knowledge. My Lord, at paragraph 57 of that decision, the court reaffirms the decision in Nicholas Kipto Arab Salat versus IBC on the mandatory nature of a notice of appeal, because a notice of appeal, my Lords, is a jurisdictional prerequisite without which the court cannot proceed. My Lord, just to add to what learned friend Mr. Obatia submitted, the notice of appeal appearing at page 1532 and 1533 would not have been fatal had it been lodged in the Court of Appeal in accordance with the rules. But at page 1533, it is stated as lodged in the High Court at Garissa, not in the Court of Appeal. So expressly, my Lord, this reaffirms what the Court of Appeal in the Musa Sirma case dealt with at paragraph, the penultimate paragraphs, where the court said, my Lords, that where a notice of appeal is lodged in the High Court, then it is clearly the intention of the respondent to file the document in the High Court. In this case, the High Court of Kabarnet in the Musa Sirma decision, because the document says that on its face. And my Lords, once the Court of Appeal, Judge Waki, Sikyale, and Ole Kantai, dismissing or striking out the notice, my Lord, reaffirmed that interpreting Rule 6, my Lord, the court must look at the intention of the parties. The Supreme Court, my Lord, in the Musa Sirma decision, petition number 13 of 2018, the full bench of the Supreme Court reaffirmed the decision of the Court of Appeal on this point. My Lord, we therefore submit that the notice of appeal appearing in page 15, 32 and 33 falls short of Rule 6. It falls short of the settled law on how a notice of appeal should be framed. My lords, short of arguing any other question, this court can only hear this appeal if it deals with a threshold as to whether there's a valid notice of appeal before it, my lords. We pray that you dismiss, strike out the notice of appeal, and if you do, my lords, then the entire appeal falls on its back, for there's nothing. What exists before this court is nothing, because this appeal is still on as filed. That's all, my lords.
Presiding Judge, could I just ask Senior Counsel Professor Ojenda to clarify one statement he has made? I'm not too sure I had him correct.
Yes, which one? Yeah, please proceed, Judge.
Senior Counsel Prof. Ojenda, perhaps you could just clarify a statement I'm not too clear on. You indicated that in interpreting Rule 6, the court must look at the intention of the parties.
Yes, my lord. The intention of the parties that is set. My lord, I'm reaffirming the decision of this court on as set out in the Musa Sirma decision, where the Court of Appeal held that the intention of the parties is derived from the document file. The document file, my lords, at page 1533, the intention of the party was to lodge the document in the High Court at Garissa and not in the Court of Appeal. So that even unlike the Babu Owino decision, my lord, where the notice was filed in the High Court but subsequently lodged in the Court of Appeal, and which the court then rescued, my lord, this notice was intended to be filed in the High Court, not in the Court of Appeal. So that's the distinction. And it is on that basis that the Court of Appeal, in analyzing the notice, and the Supreme Court agreed with them, said you look at the intention of the parties, and the intention of the parties hearing was not to lodge the notice in the Court of Appeal. It was to lodge it in the High Court. On that basis, this notice is bad. It dies. And I'm not just in response to that.
And was it ever lodged before this court? Can you clarify?
No, it was not lodged, because the lodging is lodged. The last paragraph, the penultimate paragraph, my lord, is lodged in the High Court at Garissa on the 9th of March, page 1533. It was never lodged in the Court of Appeal.
All right.
It was never lodged in the Court of Appeal, and that is why the interpretation question then comes in. My lord, just in response to the same question, my lord, this is the kind of notice that Rule 17 cannot save or cannot apply to, because it creates. This is a jurisdictional prerequisite. It is not there. There is no notice. Rule 17, my lord, would only apply where there's a proper notice or where there's some level of acceptable non-compliance. But here, there's complete non-compliance, and there's nothing before this court to even clothe this court with jurisdiction. So the argument under Rule 17.1 would not, in our view, apply to this matter. There was no notice filed. The Supreme Court has rendered itself in this decision, my lord, in Anwar and in the Musa Cherotich Sirma decisions, on the prerequisite of a valid notice before you. We pray that you strike out this notice and find that there's no proper appeal, no proper record, no proper appeal before you, my lords.
All right, thank you. We've given you 20 minutes. Thank you. I think we are done. Can we hear the other side?
Your Lordship, maybe we can go first because we are supporting the application.
Oh yeah, yes.
And then,
fine. You're right.
Senior,
right.
Yeah, Senior Counsel, Mr. Kioko Kilokumi can respond to it.
You're right. Now, how come I can't see you, Counsel, on the screen now? It's myself.
I can see you very clearly.
Oh, this is Mr. Sorry. It's all right. Okay, thank you.
I can see you. The president of the court and judges of the Court of Appeal, we support the application. And we support the application based on the following 5 grounds. Number one, if you look at page 1532 of volume 4 of the Record of Appeal, it is very clear that this notice was not filed in the Court of Appeal. To the extent that there is no notice before this court, the jurisdiction of this court cannot be triggered, has not been triggered. And there are no proceedings before this court for this court to deliberate on. Number two, if you look at the Court of Appeal election rules, your lordships and your ladyship, and look at regulation 6.5, the regulations were very, very, very onerous to the drafters and to the lawyers who will use these regulations.
Yes.
Form EPA 1 is a schedule to those regulations. Form EPA 1 is a notice of appeal, how it's supposed to look like. And if you look at Form EPA 1, your lordship, you will see that the form starts with in the Court of Appeal at. That is the drafters, we know, I think the drafters of the regulations, new lawyers and they are drafting, and the sample form has been put there. And from the form there, you could see that this notice must be filed in the Court of Appeal because the form itself starts in the Court of Appeal at. So to the extent that the person who drafted this notice did not follow the format in the schedule, did not follow the format in Regulation 6, as it relates to the content, as it relates to the orders being appealed against, this notice is incompetent. Number 3, Counsel Omwanza has referred you to the case of Honorable Letip-Tip. We rely on the case, and the Supreme Court has made a determination on what happens to a notice that is incompetent. A notice that has not been filed as per the Court of Appeal election regulations, or has not been filed at all. And we want to point out to this court, it is a constitutional issue. This court cannot disregard the decision of the Court of Appeal. If you look at the Constitution, Article 163(7) of our Constitution, and I will read for the court, it says that all courts other than the Supreme Court are bound by the decisions of the Supreme Court. Which means once a determination has been made on an issue of law by the Supreme Court, this court cannot disregard that issue, and it's bound by the decision made by the Supreme Court. So to the extent that a decision has already been made by the Supreme Court on this issue of a defective notice or a notice that has not been filed before Court of Appeal, to the extent that the jurisdiction has not been triggered, we submit that there is no notice before you, and the same, the proceeding should be struck out. We also want to rely on the case of Apungu Arthur Kibira versus the IEBC election petition appeal.
Sorry? You say Apungu what?
Apungu Arthur Kibira
okay.
versus the IEBC election petition appeal number 11 of 2018 at page 5, where Justice Waki, Sichale, and Otieno Odek made a similar finding. that a notice of appeal is a primary document to be filed outright, and it is a jurisdictional issue. Your Lordship will provide that authority to the court because this application was has just come now. But the submissions is that what triggers the jurisdiction of this court is the notice of appeal, and to the extent, number one, that this notice has not been filed before the Court of Appeal. Number two, even if the court was to use the oxygen principles, which it should not, because this is a constitutional and jurisdictional issue, even if the court was to use that, the notice is incompetent because it does not comply with the provisions of Regulation 6. And for those submissions, we submit that there is no notice before you and the jurisdiction of this court has been triggered. Your Lordship, I didn't want to go to this, but if you look at our submissions, the bulk of our submissions were based on the jurisdictional issue arising from that notice on matters of fact which have been pleaded. And to the extent that that notice itself has not been properly before this court, we submit that this court doesn't have jurisdiction to entertain this matter. Neither Regulation 17 nor the oxygen principles can save this notice. We submit that this court is bound by Article 163(7) of the Constitution to the extent that the Court of Appeal, the Supreme Court of the Republic, has deliberated on this issue and made a finding. Thank you.
Thank you, Counsel. Is there any other party who is supporting the preliminary issue on jurisdiction? If not, then Senior Counsel, Mr. Kilukumi, or whoever is addressing the court for the appellants can go on.
My Lord, Mr. Issa will address you on this issue, and if need be, I will, contribute if need be. Thank you.
Okay.
Good morning, my Lord and my ladies.
Good morning.
My Lord, the starting point, my Lord, is that this is an oral application that has been made by my learned friend, Mr. Mwanza, and with Senior Counsel Ojenda and Mr. Mwanza on behalf of the first and second respondent and supported by the third and fourth respondents. My Lord, the rules, I agree with my learned friends that these rules govern election petitions, and that's the Court of Appeal Election Petition Rules 2017. But my Lord, the submissions being made before you today are founded on a false premise. My Lord, first, let me take the jurisdictional issue. My Lord, a party who intends to strike out a record of appeal or a notice of appeal is required by these rules to file a formal application under Rule 19. And my Lord, what it says is this, that a person affected by an election petition appeal may, within 7 days from the date of service of the notice of appeal or record of appeal, as the case may be, apply. That means you make an application to the court to strike out the notice or the record of appeal on the ground that no appeal lies or that some essential step in the proceedings has not been taken within the time prescribed by these rules. And Rule 2 says, where no application is filed within the period stipulated under Sub-Rule 1, a person may not raise the issue later. So there's a statutory bar to a party raising an issue outside the timeline stipulated by the same rules that are seeking to invoke. My Lord, you would note that my learned friend for the first and second respondent filed not one, but 2 applications within the time stipulated. None of those 2 applications raised the issue that no notice of appeal was filed in the Court of Appeal, for the simple reason, my Lord, because a notice of appeal was filed and served by my learned friends. Senior Counsel Kyoko Kilukumi referred the court to the replying affidavit of our client, the appellant, Mr. Dr. Hassan Mohammed Adam, that was sworn on the 19th of May 2023 and filed in court on the 23rd of May 2023. My Lord President, Justice Ngenye, this issue did not arise at the case management or the pretrial stage because they were aware a notice of appeal had been filed. My Lords, this annexure, HM1, is a notice of appeal in the Court of Appeal at Nairobi. It is dated the 9th of March 2023.
What page is
My Lord,
it?
in that replying affidavit,
We have a record of appeal that runs
Yes.
from volume 1 to
Lord,
volume 4.
yes, my Lord, I'll come to that shortly. But on the issue of filing of that notice of appeal, my Lord, you would note attached to that notice of appeal is a receipt from the Court of Appeal of the 10th of March, 2023. And this is receipt number 00334443, confirming two things: that a notice of appeal was paid for, 450, and service fee was paid for by Sala and Company advocates, and immediately a number was issued, being Court of Appeal Election Petition Appeal number E008 of 2023. And this was paid for by way of M-Pesa, and the CTS invoice reference number is E2DDWQSB. My Lord, this was issued contemporaneously, and immediately thereafter, the Court of Appeal raised a security for costs invoice, and that was paid.
I asked you a question. Please confirm,
Yes,
when was that notice filed, because you did not refer me to the page. I just want to know the date. When was it filed?
It was filed on the 10th of March. 10th of March. And my Lord, the receipt was issued by the Court of Appeal on the 10th of March. My Lord, that was 7 days after the judgment of the High Court was delivered by your brother, Justice Dulu. It was filed at 13:44:21, which is around 1 o'clock on the 10th of March.
And did you get to know the page where it is? Because we would like to. The four volumes.
My Lord, I have consulted Mr. Sala, and there were two notices of appeal filed. This one is in the Court of Appeal, and there's a notice of appeal in the High Court that was filed. So there were two different notices.
I'm asking about the one you are referring to that was filed on 10th of March.
Yes, my Lord.
Where do we see it? Because Mr. Omanza pointed to page 1532. If you could kindly tell us the page where it is, so that
Lord,
we.
The one at page 1532.
That's the one that was going in Garissa. The one you are now referring to.
Yes, my Lord.
It's a different one from the one at page 1532, and I'm asking, where do we find it at?
My Lord, I have just consulted Mr. Mohammed Salah, and he tells me that notice of appeal might not be in the record of appeal, but it was filed in the Court of Appeal.
So how do we know it? How do we know about it? I want to look at it.
My Lord, and that's why I referred you to the replying affidavit. This issue was raised, and the replying affidavit indicated that the notice of appeal was filed. My Lord, sorry, my Lord.
Sorry?
There was a bit of interference. Sorry, there was a bit of interference. I didn't hear what you.
No. It's someone who spoke. I don't know who. Okay. Okay. So you confirm that the one you are citing in the replying affidavit is not anywhere within the record.
No, it's not the one that my learned friend was attacking in his submissions, in his oral submissions.
I'm asking you.
Presiding Judge, I'm not.
Sorry, Judge, go on.
No, I
Judge?
think we are on the same line. We are on the same line. I was going to say, could Mr. Issa just refer us to the page where this notice is, or that it is not within the record?
No, my lord. I was sorry, my lord. I was telling his lordship, the president, that the one in the record of appeal at page 1532 that Professor Jenda had referred to in volume 4 is the one that was filed in the High Court, and that's a different notice of appeal from the one that was filed in the Court of Appeal. So there are two different notices of appeal, one filed in the Court of Appeal and one filed in the High Court.
But you're not answering the crux, the main question. The question is, the one you're saying was filed in the Court of Appeal and a receipt was issued. Is it in the record of appeal or it is not? And if it is there, at what page of the record of appeal do we find it? So that we can contrast it with the notice that is at page 1532.
And my lord, that's what I'm saying. It is not in the record of appeal that you have before you, the notice of appeal that was filed and the receipt that was paid for.
Okay.
But my lord, I'm just coming shortly to that.
All right, move on.
My lord, yes, my lord. My lord, the notice of appeal having been filed and served on the parties, my lord, it confirms with the requirements of Rule 6 of the Court of Appeal rules. And my lord, when you look at the replying affidavit that sought to strike out the record of appeal, it will confirm that that notice was filed. And it was served on the parties in terms of Rule 7. My lord, Rule 8 I'll come to Rule 6 in terms of the form of that notice. My lord, the contents of a record of appeal require that all the documents set out in Rule 8 should be included in the record of appeal. And my lord, that includes, I concede, the notice of appeal under Rule I, and then J says such other documents, if any, as may be necessary for the proper determination of the appeal, including any interlocutory proceedings which may directly be relevant. But my lord, there is provision of filing a supplementary record of appeal under Rule 8, sub-Rule 5 of the rules of this court. It says where the High Court, the High Court does not avail any of the documents required under this rule, the appellant may proceed to file the record of appeal and the supplementary record of appeal within 7 days thereafter. So, my lord, Rule 8.5 provides for the filing of a supplementary record of appeal. Now, my lord, the notice of appeal having been filed within the stipulated time, the issue of jurisdiction is only affected if no notice of appeal is filed within 7 days. And that is the basis of the decision in the Anwar Ole Tip Tip and the case Apongo Arthur Kibara, the Malane friends have YouTube. But my lord, when you retire and look at the decision of the Supreme Court, that decision does not support the position that is being advanced before you today. The decision of the Supreme Court dealt with a different issue. In the appeal before the Supreme Court, there was an appeal from an interlocutory application where no notice of appeal had been filed within the time stipulated by the rules. My lord, in the Musa Sirma case, which is different from what we have before you today, a notice of appeal had been filed in the High Court only, and that was lodged in the High Court. And therefore, on the basis of the facts that were in the Musa Sirma case, there was no valid appeal in the Court of Appeal. My lord, in the case before you today, a notice of appeal was filed in the Court of Appeal, and the security for cost paid, and the receipt is in the Court of Appeal. And my lord, on the issue of filing a supplementary record of appeal, my lord, you had Professor Ojenda saying that Rule 17 applies in normal election petition of appeals for enlargement of time or filing any other document except a notice of appeal. But my lord, that extension of time will only apply to the filing of a supplementary record of appeal to place the notice of appeal that was filed in the Court of Appeal within the stipulated time under Rule 17. So, my lord, to answer you, President of the Court of Appeal. Is the appeal faulty? Our respect for submission, it's not, because a valid notice of appeal was filed. It's part of the record in the replying of affidavit of the appellant. The only issue would be that it was not included in the record of appeal that was presented before you. And can that be cured? Yes, and that's where Rule 17 comes in. That was preempted by Senior Counsel Ojenda, that says the court may for sufficient reason extend or reduce the timelines prescribed by these rules. Upon such terms and conditions, it may deem just and expedient, and the reference in these rules to any time shall be construed as a reference to that time as extended or reduced. My Lord, that rule does not apply to only two timelines. Those ones set out by the elections, by the Constitution and the Elections Act 2011. My Lord, it is a respectful submission that a filing of a notice of appeal within 7 days and including it in the memorandum of appeal within 30 days of filing of the notice of appeal is a stipulation in the rules and not in the Elections Act or in the Constitution. And so, my Lord, as a matter of law, this objection, because it is really a preliminary objection, is not well founded under the rules, under Rule 19, because no formal application was filed. And two, as a matter of fact, on the basis of the replying affidavit that's before you, it is not well founded because a notice of appeal, a valid notice of appeal, was filed by the appellant. And this court has the requisite jurisdiction to deal with the appeal. Let me come to the third issue before I cede the ground to Senior Counsel Kilukomi to finalize the submission. A submission has been made that under Rule 6, the notice of appeal must set out the grounds of appeal. That submission is incorrect. Rule 6 only says this. A notice of appeal shall be filed, Rule 6.2. A notice of appeal shall be filed within 7 days of the date of the decision appealed against. And then Rule 3 says, a notice of appeal shall be in separate numbered paragraphs and shall, A, specify whether all or part of the judgment is being appealed, and if part, which part. So the notice of appeal that is has been annexed to the replying affidavit appeals against the whole decision of the High Court, not only part of it. Then B says, provide the address for service of the appellant and state the names and addresses of all persons intended to be served with copies of the notice. Has that been complied with, my Lord? That has been complied with in the notice that was filed in the Court of Appeal. And then C, contain a request that the appeal be set down for hearing in the appropriate registry. Has that been set out in the notice, my Lord? Yes, that has been set out. My Lord, Rule 6 does not require that the notice be lodged, or it indicates that it's been lodged in the Court of Appeal. You had some submissions, say, by Senior Counsel Professor Ojenda, saying that the notice that was filed in the High Court showed that intended to be lodged in the High Court and not in the Court of Appeal. The Court of Appeal rules do not require any specification that that notice has been lodged in the Court of Appeal. And then, my Lord, Rule 5 is the one that my learned friends are clinging on, and they say that a notice of appeal shall be substantially in Form EPA1 set out in the schedule and shall be signed by or on behalf of the appellant. My Lord, when you look at the schedule and the form that is EPA1, my Lord, you're very familiar with it.
Judge President, Judge Presiding Judge, I think we have lost our sister, Judge Obondi.
Oh,
no,
sorry.
No, Judge. I am here and I'd sent a message to both of you and also on the chat that I am having activity problems, so I've switched off my camera to improve my connection. Yes,
thank you.
And I also clicked on your phone. Yeah.
Thank you, both judges. I have not seen that. Thank you.
I beg your pardon.
Yes, Mr. Issa, what do you say?
Yes, my Lord. My Lord,
yes.
A submission has been made, and I heard that being made by my learned friend, Mr. Mwanza, and my learned friend, Mr. Mahat Somane, that the rules, the Form EPA1 requires that the grounds be set out in the notice of appeal. My Lord, the rule I've read does not require the grounds to be set out in the notice of appeal. And none of that, it just said that it should be numbered sequentially. Ours is numbered. It shows the notice of address. It shows everything that the rules requires. That's all the rules requires.
I think Mr. Omanza referred to 6.3b, if I'm not wrong. What does 6.3b? I don't have the rules with me right here. What does 6.3b say?
6.3b, a notice of appeal shall be in separate numbered paragraphs. That's what 3 starts. A notice of shall be in separate numbered paragraphs and shall be, and unless the rules were amended, says provide the address for service of the appellant and state the names and addresses of all persons intended to be served with the copies of the notice.
My Lord, I'm sorry. I think my learned friend is referring to the rules which were repealed.
Because this is it.
Your Lordship, we confirm those are the repealed rules. The rules were amended.
I can just confirm that. And my Lord, when you look at the form at the back of the notice, I can just confirm if that is correct. It shows the format. It shows the format of the notice of appeal that you need to indicate what and intends to appeal against this whole of the state or such part as decides that, and then you set out if you are appealing against part of the decision, you need to indicate, and then you need to indicate what reliefs you seek. But my Lord, Rule 5 of Rule 6 says a notice of appeal shall be substantially in form of EPA1. So the issue is that there must be substantial compliance with the regulations and the rules. So, my Lord, if the notice of appeal is in substantial compliance with what is required, and it indicates that you appeal either against part or the whole of the ruling, my Lord, that notice is compliant. And, my Lord, when you look at the contents of the record of appeal, my Lord, that Rule 8, even as amended, would show that other than the documents stipulated from paragraph A to I, which mandates that a notice of appeal should be filed, it says such other documents, if any, as may be necessary for the proper determination of the appeal, including any interlocutory proceedings which may be directly relevant. And my Lord, that also must be read together with Rule 4. And that is what I want to take the Court of Appeal to. My Lord, the Supreme Court says, in terms of how the two rules, the main Court of Appeal rules and what the election petition rules provide. My Lord, when you look at the decision of Honorable Anwar Odekiptik, which has been referred to and was reported in 2019 EKLR, the Supreme Court had to deal with that issue at Rule 68. It says that when you look at Rule 6 of the Court of Appeal rules, it says this rule must not be read in isolation. At Rule 60, at paragraph 67 of the judgment of the Supreme Court, they set out Rule 6, and it's the one that I've just read to you. And then Rule 60, and then paragraph 68 of the Supreme Court says this rule must not be read in isolation and must be read together with the following rule, and that is Rule 4.1, where it says where there is no applicable provision in these rules, the provisions of the Court of Appeal Rule 2010 relating to civil appeal shall apply to an election petition appeal insofar as they are not inconsistent with the rules. My Lord, why is that important? My Lord, Rule 68 invokes, Professor Jenda is talking in the background. If my land is senior,
Professor Jenda, you need to mute your microphone, please.
Doesn't have this.
Senior Counsel or Jenda, are we communicating?
Your Lordship, the mic is muted.
Yes.
Let me just check if there's another that had logged.
Yes, because we are here in Senior Counsel interrupting Mr. Issa and the court as well.
Yes, my Lord. So I'll just making this point that says that where there's no applicable provision in these rules, the provisions of the Court of Appeal rules relating to civil appeals shall apply to an election petition appeals insofar as they are not inconsistent with the rules. My Lord, why is that important? Because the requirement for a memorandum of appeal is in the in the Court of Appeal rules 2010 regarding all civil appeals to the Court of Appeal. And my Lord, at paragraph 69 of the Supreme Court, it says, this being election petition regulations, where expeditions dispensation of matters within a time limit is key, the use of the word shall in Rule 6 illustrates the rule is mandatory in nature. And in the second, it is important to note that it envisions the word appeal arises out of a judgment, and then they go on to deal with that. They invoked that rule to deal with the issue about where an interlocutory appeal has not been filed. But my lord, what the Supreme Court was saying is that any election court, when dealing with an election petition, you don't need to read these rules in isolation. So in this election petition rules, there is no provision for a memorandum of appeal. But in the in the Court of Appeal rules, a memorandum of appeal is one of the necessary documents that clothes the court with jurisdiction dealing with a civil appeal. And my lord, that read together with the rule that I've just given you, that is Rule 8, sub Rule 5, and Rule 8, my lord, sub Rule 481J, a memorandum of appeal then fulfills the purpose of setting out distinctly the grounds on which an appeal has been preferred by an appellant to the Court of Appeal. Now, in the appeal before you, you have a memorandum of appeal that sets out succinctly what the grounds of appeal are, and it also has the prayers that are sought in the appeal. My lord, that addresses the issue of whether you have any reliefs that are before you, and when you read Rule 4 and read Rule 6 and 8, my lord, this appeal is properly before this court because there is no requirement for a memorandum of appeal in the election petition rules, but there is a requirement in the Court of Appeal Rules 2010. And therefore, my lord, and the Supreme Court says that where you find that the rule is silent, it does not mean that those rules in the Court of Appeal, Court of Appeal Rules 2010 are not inapplicable. It's only that you give priority to the rules in the election petition rules, but it does not invalidate the civil appeal. Well, for those reasons, and for the reasons that are set out, my lord, this preliminary objection, because that's what it is, because it's not a formal application, is incompetent. My lord, it was not filed within the timeline stipulated under Rule 19, and as the Supreme Court rule says, the Supreme Court judgment quite correctly says, my lord, and even the Court of Appeal decisions, when you do not file that application to strike out the notice of appeal of the record of appeal within those 7 days stipulated in the rules, my lord, you cannot raise that issue at the hearing or substantive. And my lord, this I'm asking you to invoke the decisions of the Court of Appeal, which are numerous, in the interpretation of your Rule 84 now, I believe is Rule 85, where a party does not file an application to strike out a notice of appeal or a record of appeal in normal appeals within 30 days, my lord, that is deemed to have been waived. And my lord, the same applies with equal force to the preliminary objection that has been taken before you today. That preliminary objection, my lord, is not well-founded in law. It is not factually well-founded. And my lord, we urge you to dismiss that preliminary objection. And my lord, invoke Rule 17, and we will file and serve a supplementary record of appeal within a day of your ruling for us to place it formally on record before the court so that the substantive appeal can be heard. My lord, for those submissions, I cede the ground to the Senior Counsel Fulukumi to finalize on this preliminary objection that has been taken by the respondents.
Your Ladyship and my lord, I wish to draw the court's attention to an important principle in Article 159(2)(d) of our Constitution. This honorable court is enjoined by the Constitution to administer justice without undue regard to procedural technicalities. The court is therefore called upon to administer substantial justice and to overlook procedural missteps, procedural lapses that do not hamper or hinder the administration of substantive justice. In this petition before the court, is there a notice of appeal? It is our submission before the court. There are two notices of appeal. The first notice of appeal appears on the record at page 1532 to 1533. That notice of appeal in our humble submission is
just hold on. A Senior Counsel agenda. There's something that is coming from your mic. Please, can you?
No, my Lord, my mic is muted. I think it's on Bati's. I heard on Bati's voice. I am. Mine is muted, my Lord. I'll take it back.
Yours is muted because we had heard you speak a number of times and you were asking questions to your colleague there.
No, I think it's on Bati's. It's my colleague on Bati's.
No, clearly, earlier it was yours, but Mr. Umbati and any other council, please, let's just mute your microphones, unless you are addressing the court. Thank you.
And so, my Lord, my first argument is we have two notices of appeal. The first notice of appeal appears on pages 1532 to 1533. That notice of appeal in our ambo submission is sufficient. It may be inelegantly drawn. It may lack some details, but nonetheless, it is a notice of appeal clothing this court with the jurisdiction. And my Lord, we have to apply law in a purposeful way, not in a mechanical way. What does a notice of appeal do? It notifies the parties that a dissatisfied participant or litigant intends to challenge a decision of the High Court. That's the purpose it serves. Were the parties notified of this dissatisfaction? They were notified and they were aware of it. We submit this notice is enough in itself to clothe the court with the requisite jurisdiction. The second submission, my Lord, there is before the court, it is not in the court record, it is not on the records of appeal. The records of appeal do not contain this notice of appeal, but we have a second notice of appeal. And it has been placed before the court. It is available in its e-filing system.
Senior counsel, can I just beg you indulgence 1 minute? 1 minute?
Yes, my Lord.
It's okay. I'm just making a nice adjustment. Thank you. Proceed.
Thank you. My Lord, I'm saying we have a second notice of appeal, and that second notice of appeal has been placed before the court through the replying of an affidavit of Hassan Mohammed Adam, the petitioner, the petitioner and the appellant. It is available in the court's e-filing system, and it's therefore a document that is available to the court, whether or not it is in the record of appeal. More significantly, the court could grant us time to have a supplementary record placing that notice of appeal in the record of appeal. We urge that this notice of appeal, standing alone, is enough to clothe the court with jurisdiction to hear and determine the petition. My Lord and your Ladyships, this case asks for it to be heard on its merits and not to be dismissed on technicality. The electorate in Wajir County would want to know whether the governor of Wajir County was properly and constitutionally elected to that position. That's a matter that calls for substantial justice and not procedural technicalities. For that reason, we urge the court to dismiss the preliminary objection as coming too late and in violation of the rules they intend to ride on. Thank you, my lord, and your ladyship.
Thank you. Mr. Omonza, do you have any rejoinder?
Yes, my lord, I have a short rejoinder. My lord, the first is that, my lord, this is a preliminary objection, and therefore it can be raised in according to Mukisa Biscuits at any time, at any moment, and without even notice. Secondly, my lord, my learned friend referred you to the decision, which I think.
So what's your take on Rule 19?
My lord, Rule 19. Sorry?
The one were referred to by, is it Mr. Issa? What's your take on it?
Yes.
Yes.
Just a minute, my lord. Let me have a look at it. Rule 19. My lord, I don't think Rule 19 would come to their... just a minute. Yes, my lord, Rule 19 is not applicable on issues of jurisdiction.
I think he referred, Mr. Issa, if I got you well, you cited Rule 19 too. Unless you are referring, you're citing the repealed rules.
Yes.
What does your Rule 19.2 say, Mr. Mbati?
My lord, the rules I have says that the court shall immediately after the pre-hearing conference commence the hearing of the appeal.
All right, just proceed. We will look at the rules. Proceed.
All right, my lord. Secondly, my lord, I would refer you to a decision by this court. The decision that was alluded to by my learned senior Professor Ojenda, the decision of Apungu Arthur versus IBC. It is a decision by this court, and the same issue, my lord, was raised before the court. And this is what the court says. I will just read the paragraph that is applicable. It says quite plainly, it answers.
Just tell me the paragraph.
My lord, this decision has no paragraphs.
Okay.
Yeah. It says that quite plainly, it answers to none of the prerequisites set out in Rule 6, and it cannot therefore be a notice of appeal. It even refers to appealing against the whole decision, including factual matters which do not lie in this court. The applicant and his counsel admit as much, and that is why they seek time for filing a fresh notice of appeal. Their plea that the rules were in transition and were hence easily overlooked cannot be a serious assertion, as the rules had been in existence for more than 8 months before the election petition was lodged. I agree with the respondents that the document filed was a nullity, as it purports to be a notice of appeal filed under the rules. It follows that no notice of appeal was filed in this matter, and there can be no jurisdiction granted to the court to consider the extension sought. The court has no business crafting a jurisdiction it does not have, whatever amount of sympathy it may have to the applicant. It has to down its tools. My lord, I pray that you apply the same reasoning by Justice Odek in that case. My lord, my learned friends seem to concede that the notice that appears at 1532 is not the notice that is in the record of appeal. Therefore, my lord, then the question that would follow is then what is the appeal that is before you? Under Rule 8, my lord, of the rules, a notice of appeal is one of the rules that is mandatory as being part of the record. And if you were to exercise your jurisdiction and allow them to bring a new... Sorry, my lord?
Mr. Mbati, do you have the one they alluded to in the replying affidavit? Because we don't seem to have it, but...
My lord, I also don't seem to have it, actually.
They say you are served with a replying affidavit of Mr. Adam, where the notice is next.
My lord, what I have their submissions. the third and fourth respondent submissions.
They are,
and our submissions.
I think it's replying affidavit, not submissions. Replying affidavit.
My Lord, I apologize. I do not seem to have it with myself.
Okay, proceed.
Yeah. So that, my Lord, when they tell you allow us to bring in a notice of appeal to the record through a supplementary record, my Lord, they would be asking you to expand time that is allowed by law. My Lord, based on those submissions that we have made a case that this appeal has no merit because there is no notice to invoke the jurisdiction of this court.
My Lord, may I just add 2 points in response to Mr. Issa's submissions, my Lords. Mr. Issa has conceded that the record of appeal, that the notice of appeal filed existing at pages 1532 and 1533 is the notice known to the court. That is all that the court has, my Lords. And my Lords, Rule 8 of the rules of this court, the 2017 rules, my Lord, set out what should be contained in a notice of appeal, in a record of appeal. And my Lords, the record of appeal at Rule 8 I should include a notice of appeal. And my Lord, Rule 8 is couched in mandatory terms. The record of appeal shall contain. And my Lord, if you look at Rule 8.5, that record that shall contain a notice of appeal is required to be filed within 30 days from the date of the judgment of the court. That means, my Lord, that by the 3rd of April 2023, because judgment was delivered on the 3rd of March, the record of appeal should have been in place. My Lord, what my learned friend has told this court is that there is another notice of appeal filed on the 10th of March 2023, which has not been seen by this court because it is not part of the record. My Lord, my learned friend seeks an extension of time to enable them file a supplementary document in the nature of a notice of appeal. My Lord, can this court extend time to a party to file a primary document that will give this court jurisdiction to entertain the documents filed in court? My Lord, that my learned friend has admitted that there is no valid notice of appeal on record speak to the existence of nothing before this. And my Lord, this court cannot extend time to lodge a record of appeal because a notice of appeal is a primary document. It's a primary document which must be contained in a record of appeal. It is not any other document that can be filed with a supplementary record, because what has been filed before this court is not a notice of appeal as contemplated by the rules, because it is not lodged in the court of appeal. This court, therefore, my Lord, has no jurisdiction to extend time, because an appeal before this court, my Lords, must be filed under Rule 8.5 within 30 days. Rule 8.5 and Section 85A of the Elections Act, within 30 days of the judgment of the High Court. So this court's hands are tied. It cannot move, it cannot extend time as sought by learned friend Issa Mansour. My Lord, has the court had time to deal with 159 2D? Yes, my Lords. There are decisions of this court, and specifically, my Lord, this court had occasion to interpret the rules. And in Kisumu election petition number 34 of 2018, Jeremiah Nyangwara Matoke versus IBC. Judge Githinji, Judge Mohammed, and Judge Okwengu dealing with the question of extension of time of the nature sought. And my Lord, I submit that the court declined to extend time because such extension would violate Section 85A of the Elections Act. Because timelines, my Lord, for election petitions are strict, because elections petitions must be determined within time, my Lord. My Lord, to Rule 17 that my Lord friend Mr. referred to. My Lord, Rule 17 contemplates expressly that applications be made, but with a caveat in Rule 17, my Lord. My Lord, one is where no appeal lies, and two, where some essential step in the proceeding has not been taken within the prescribed time. My Lord, we are not dealing with time here. We are dealing, my Lord, with the failure to file a notice of appeal, and therefore a jurisdiction question, my Lord. My Lord, we submit that where issues of jurisdiction are in question and where a notice of appeal is in question, my Lords, this court cannot apply Rule 17. In fact, it is inapplicable, because this court must have jurisdiction first to be able to apply Rule 17(1), allow a step to be complied with. But in this case, my Lord, there is no basis for this court to begin to act because it is not clothed with the requisite jurisdiction, there being no notice of appeal at all. And now they've admitted no notice of appeal was lodged in the Court of Appeal. My Lord, lastly, just to complement what my learned friend has submitted. My Lord, my learned friend, Mr. Issa, seems to be reading from a different script. My Lord, Rule 6 has clear provisions on what must be contained in a notice of appeal. And my Lord, Rule 6, 3C expressly provides that a notice of appeal must have grounds, and that Mr. Issa was trying to avoid. Grounds and relief, 3C and 3D. And if all these non-compliance issues would perhaps go into 17(1), but there is no notice of appeal as admitted now, my lords, on record, lodged in the Court of Appeal, is what kills this appeal. All these records as filed count for nothing. And this court cannot rescue this appeal, even under Article 159(2)(d), because there's nothing to rescue, my lords. We submit that to strike out the documents before you, for there is no basis for the exercise of the jurisdiction of this court. That's all, my lords.
Your Lordship, we know we don't have a right of rejoinder or say anything, but to answer a question you asked about Rule 19, I want to refer to you to your decision, election petition appeal number E004 of 2022, Siad Abdullahi versus the IBC.
That doesn't have the right. We object to that line of trying to submit again as a respondent to the preliminary objection.
Your Lordship, it's a question that the court had asked. I was just clarifying, and it is your decision. You have already made a determination on Rule 19. We just want to refer that to the court.
Not asked any question, and therefore you cannot reply on a question that was not asked.
Thank you, Council. We have had both of you, and let's give you a date for the ruling. I see that you confirm that the appeal was filed on 28th of April, isn't it?
First,
yes, my lord.
1st of April.
Oh, sorry, 1st of April. 1st of April. So 6 months will take. We still have a bit of time. It will take us all the way up to October, but we will still endeavor to give you a ruling in good time. We'll give you a ruling on 21st of July.
Most obliged, not.
Now,
Most obliged.
We are most obliged.
Most obliged.
What we will request, what I will request you do is, upon service of notice for delivery, we would ask that you attend virtually for delivery, although ordinarily we just email rulings. Attend court for delivery in the event that we need to give any directions or we need to say whatever we may have to say. So attend court for delivery on that particular date.
Most obliged, and have a good day.
Thank you.
We shall attend.
Thank you.
Thank you.
Sorry, did I hear Judge say something? Okay, thank you. Thank you. You may exit the platform, cancel.